Let's look at a situation where you've got a contract, all the elements of the contract are satisfied, so the contract has already been formed. However, the validity of that contract is destroyed because of the presence of certain factors, and these factors are labeled as vitiating factors. So the purpose of this video will be to talk about the vitiating factors and talk about how a contract would be classified as void or voidable when if a court were to find that a vitiating factor existed. So as I said, you've got a contract. It's legal in the sense that all the elements of formation are satisfied. However, there are certain factors that impeach the legal validity of that contract, and these factors are referred to as the vitiating factors. Whether the court deems the vitiating factor as resulting in the contract being void or voidable depends on whether the contract can be performed under law. So I'll give you an example. If there was a contract between two parties, legally, if you look at the elements of formation, they have all been satisfied, but the contract itself was about, killing someone else, right? So a contract to kill someone else. Now that contract is not valid by law, of course. So the contract is void from the start. There was no contract to begin with because the act was not lawful. For a void contract, as I said, the contract has never been valid from the start. You can't enforce obligations, and the innocent party can't sue for damages. So what would happen in a case where the innocent party had already conferred goods or money to the other party? Well, in that case, what would take place is that the court would still apply some sort of remedy, and that's a remedy of restitution, and that's where the defendant would be ordered to give back that that benefit that they received from the innocent party, give it back to the innocent party. That's under a void contract. In a voidable contract, the law views the contract as binding, so it was binding in the past, but since the vitiating factor is present, from now on, the contract is no longer binding. And the innocent party has the option of rescinding the contract, so they have the option of canceling the contract. Now, given that the innocent party has the option of rescinding the contract, they also have the alternative option, which is to affirm the contract. So they get to choose. And courts usually can tell whether a party affirms or rescinds based on the conduct of the innocent party. So if the party continues on with the contract and continues on with its obligations, performing its obligations, then the court would deem that the innocent party is affirming the contract. Any delay by the innocent party in rescinding the contract would indicate that it's affirming the contract, and that's how the court would look at it. So moving on to vitiating factors. What are the vitiating factors? Factor number one, mistake. Factor number two, duress. Factor number three, misleading and deceptive conduct. And then factor number four is unconscionable conduct. Let's have a look at each one of these separately. So starting off with mistake. A fundamental thing to understand is this concept of operative mistake. So that's where the mistake is fundamental to the operation of the contract. And such a mistake would render the contract as void. So if the mistake is not fundamental, then the court wouldn't deem the contract as void. It can be deemed as voidable, maybe, um, or it would just allow the contract to carry on. However, if it is an operative mistake, then the contract will be rendered as void. The mistake can be classified into several classifications. So the first classification is common mistake, and that's where a mistake is committed by both parties on the same thing, and that thing is a fundamental aspect of the contract. Now, when I talk about fundamental aspect, I mean it's on the subject matter. So if it's on the subject matter and that is so fundamental in the contract, then the contract will be found to be void by the court. What if it's a common mistake on the terms? So both parties, they make the same mistake, but it's on terms intended. So, they intended something else, but the contract says something completely different. Well, here the court is very unlikely to find that the contract is void. The court will deem that the contract is not void, and it might ask that the mistake be rectified. So one of the parties would need to rectify that term in the contract, but the contract can carry on. The second classification of mistake is known as mutual mistake. So in this case, the two parties, they differ in their understanding with respect to a fundamental aspect of the contract. And in these cases, the court again can find that the contract is void. So it's not necessarily that the court will find that the contract is void because of a mutual mistake, but depending on the nature of the mistake, the court can deem the contract to be void. The third classification of mistake is unilateral mistake. And a unilateral mistake is a mistake by one party, unilateral, that one party has a mistaken belief with respect to a fundamental aspect of the contract. So notice that in mistakes, we're constantly referring to this keyword fundamental aspect. So it has to be about a fundamental aspect of the contract. Now, in the case of a unilateral mistake, the court is very unlikely to find the contract void. Generally speaking, the courts try to avoid finding contracts void. So they want to make sure that the contract, given that it was formed and that all the elements of formation have been satisfied, they want to try to respect the contract. But if it was so fundamental, the mistake was so fundamental, their court can't ignore that, and it will definitely find that the contract is void. Okay, an important question over here. What if it was a unilateral mistake and it was in pricing? And this is important in construction. So let's say, a builder makes a mistake in pricing a tender. So they submitted a tender, and in that they made a mistake in the prices. Would the court be able to ask for rectification? Well, the court will not ask for rectification. In this case, the contract would still stand. So if the principal had accepted that offer from the builder, then the contract would stand, and the prices, even though there were a mistake in the prices of the builder, they would still stand. And an authority case is the one that you see listed in front of you on the screen. Okay, so we're done with mistake. Let's move on to duress. And duress is the second vitiating factor. So this is where one party coerced another into entering the contract. And if the coercion prevented the other party from exercising free will, then the contract will be found to be void. Now, when it comes to coercion, there's different levels that the courts would look at. But if the coercion is such that the threat was of sufficient gravity, that's where the court would find that the contract is void. In terms of threats, when it comes to duress, they can be physical threats or they can be economic threats. And an example of an economic threat is presented in the English case that you see in front of you on the screen. Moving on to the third vitiating factor, misleading and deceptive conduct. Now, this is covered in the legislation, so Section 18 of the Australian Consumer Law. And Section 18 of the Australian Consumer Law forbids misleading and deceptive conduct. It applies to both contracts that are between businesses and consumers, and also contracts that are between businesses. The defendant for misleading conduct, the defendant would be found to have led the innocent party into the error. So that's how the courts would classify that behavior as misleading. In terms of deception, so the defendant would be found to have intended to be dishonest. Now, the burden of proof over here is really high. So usually people just stick to proving misleading conduct because both of them are actually covered by the same section. In terms of liability, under Section 18, it's a strict liability in the sense that if the guilty party were to mislead, but it did that unintentionally, so it did not mean to mislead the other party into the contract, but it did so unintentionally, the court would still deem it as liable, given that it's a strict liability. The final vitiating factor is unconscionable conduct, and again, this is covered in Section 20 and 21 of the Australian Consumer Law. It's about unfair exploitation. So you have a stronger party that exploits a weaker party. And an example or an authority case would be this Australian case. And the weakness in this case was the fact that one of the parties, they had trouble understanding English, so their English skills weren't that good, and the bank unconscionably led them to signing for a mortgage, and it was found to be unconscionable conduct by the bank. Now, it's important for the court to clearly see that the party, so the guilty party, had acted in an unfair way, and it has to be the party that has the upper hand. So it has to be in a stronger position compared to the weaker party that has some sort of disability. This unconscionable conduct is part of equity law in the courts, and as I said, it's nowadays it's covered in Section 20 and Section 21 of the Australian Consumer Law.